All right, Deputy, are we ready on anyone?
Is this the same room? Or is this the new area?
All right, Mr. Schmidt, are you ready?
Good, good.
All right, who do you have with you?
Tessa Brennan.
All right, this is cause numbers 2019-423 and CR 21-124, State versus Tessa Marie. First, set for pretrial on each case. Go ahead, Mr. Schmidt.
This time, Judge, we don't have any contested that we want to bring before the court. We'd ask that to be set for a docket call. If the court has any time on that October 12th docket, I would appreciate that. If we still have openings.
Okay. Court will set Ms. Furr for a docket call on October 12th at 1:30 if she remains in custody, 9 a.m. if she's on bail. Is this Mr. Horton?
Mr. Fulton, Judge.
Carl Lynn Fulton Jr., CR 21-176, docket call.
That's correct, Judge. We've received an offer to the state, which I've discussed with Mr. Fulton here today. Any resulting conclusion to his case is going to have collateral consequences with potentially with the parole board. I'd ask for another docket call so I could discuss fully with Mr. Fulton all of those collateral consequences.
All right, court will set Mr. Fulton for an additional docket call on October 12th. Who do we have, Mr. Schmidt?
This is Ronald Brown.
CR 19-8, CR 21-14, Mr. Brown. Motions to revoke in each case.
It shouldn't be, Judge. One of those is a new indictment. We have one motion to revoke the indictment. I can't tell the court that we received an offer from the state. I've discussed it with Mr. Brown. He's going to accept that offer. We'd ask that it be set for a plea on that October 12th date.
Is it both cases? Which one is the, like I said, my docket shows motion to revoke on both. Which one's the non-MTR?
It's a CR 21-14. It
Should be pretrial?
Yes, sir.
All right, and you want me to set both of them for pleas?
Yes. Set them both for a plea on that October 12th date. That's okay.
All right, court will set Mr. Brown for October 12th to enter his plea.
Judge, the last one I have is John Horton. I filed a motion suggesting competency issues. They're not bringing him up for the same reasons as previously. I'd ask that he be evaluated. We set him for a status on the competency.
Is that a new filing or is it something that?
It's a new filing, Judge.
Okay,
It's a new filing.
okay, I'll review that. Let's go ahead and set Mr. Horton then for, we'll just do a status on October 12th. For the competency evaluation. And I'll let you know here quickly on whether I'm going to order that or not.
Yes, sir. That's all I have. Can I be excused?
Yes, sir. Thank you very much. We're having an issue with a camera there. Anyone at the jail? I don't know if it's bandwidth issue or what.
It's bad. Up there.
I don't know if there's an autofocus or what, but
How does right now it looks good from our end. How does it look at your end?
it looks fine now, but just a moment ago it blurred out. Is there like a focus button that's turned on that should just be turned off, or do you know?
I have Zooms, I have phone, and I have microphone.
Well, maybe it was just a bandwidth issue.
Maybe it was Mr. Schmidt.
It says magnetic personality.
Yeah. Are you ready for Mr. Manning?
Yes. Here, this is CR 21-226 and CR 21-227, Ina McMillan.
That's correct, Judge. We'll be proceeding today on a plea. The CR 21-226 will be resolved under 1245, and we'll be playing to CR 21-227.
Okay, what are the terms?
The terms are going to be 5 years TDC, a $2,500 fine, court cost in the amount of $290, and reimbursement in the amount of $20. Additionally, she'll have 166 days credit.
Any restitution being ordered from the prohibited substance?
No, Judge.
Okay, so that's all the terms.
That's correct, Judge.
All right, Ms. McMillan, if you will, ma'am, please raise your right hand so I can place you under oath. Ma'am, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, let me put your hand down. And Ms. McMillan, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you?
Yes, sir.
Feel like you've had enough time to discuss your cases with him and have all your questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
And wherever your signature appears throughout those documents, you're telling me that that's your true and correct signature and that you only signed once you understood what you were signing?
Yes, sir.
All right, Mr. Manning, do you believe your client to be competent today?
She is, Judge.
You explained to her legal and constitutional rights?
I did, Judge, as well as her waiver of those.
All right. And Ms. McMillan, you heard Mr. Manning read the terms of your plea agreement to the court. Is that your understanding? Is that what you're asking the court to approve today?
Yes, sir.
All right, Ms. McMillan, you're charged by indictment with a third-degree felony offense of evading arrest or detention of the vehicle. Carries a range of punishment of not less than 2 years or more than 10 years, confinement in TDC, prison, and a fine not to exceed $10,000. That means any plea agreement or sentence handed down by a court or jury must fit within that range. And I see here that the proposed plea agreement would fit within the legal range of punishment for that offense. You understand that?
Yes, sir.
So understanding the plea agreement, understanding the range of punishment, Let me ask you at this time, how do you plead to that offense?
Guilty.
And are you pleading guilty because you are guilty of committing evading arrest or detention with a vehicle?
Yes, sir.
Has anyone threatened, forced, or pressured you today, Ms. McMillan, to plead guilty to this charge?
No, sir.
All right, court will accept the defendant's plea of guilt at this time. Mr. Manning, any objection to states one?
No objection.
All right, states one is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. State, can you read me the facts to support the plea? State. I'll need the facts to support the plea from Ms. McMillan.
Hold on a second, Judge, I'm pulling it up.
Or Mr. Manning, facts, that's fine.
Yes, Judge. I just brief presentation of the facts. Ms. McMillan was driving on I-20, I believe. There was a attempted stop to be made. She continued driving for some distance. Upon being stopped, she recognized that the police had been behind her. I believe that she had stated that she was trying to find a safe place to pull over or safe location. There were some driving facts in regards to avoiding collisions or whether or not there's an intention of stopping. And there was a spike strip deployed near the bridge at exit 540. The spike strip did puncture both tires. And when she came to a stop, she was taken out under a felony stop, given her Miranda warnings. And during the search of her purse at the jail, they located drug paraphernalia.
Thank you, Mr. Manning. Okay, Ms. McMillan, based on the facts as presented in State's Exhibit 1, the court will find that there's sufficient evidence to convict you of evading arrest or detention with a vehicle and also prohibited substance in a correctional facility. The court will follow the plea agreement in this case. Court hereby convicts you of evading arrest or detention with a vehicle, assesses your punishment at 5 years confinement in the Texas Department of Criminal Justice State Jail Division. Texas Department of Criminal Justice Institutional Division. Court orders you to pay a $2,500 fine, $290 court cost, $20 reimbursement fees. Court will award you 166 days credit towards your 5-year sentence in this cause for time already served. And the court will dismiss under section 1245 CR 21226. Ms. McMillan, whenever you are released from the Texas Department of Criminal Justice, I'm going to order you to report to the Van Zandt County Courthouse so you can make arrangements to pay off your fines and court costs. I'm going to have you step to your left there to be fingerprinted with the bailiff. Good luck to you.
Judge, I believe that concludes my business. May I be excused.
Yes, thank you, Mr. Manning.
Thank you, Judge.
Mr. Ashmore, are you ready?
We are ready.
All right, is this Lauren Foley?
Yes, sir.
Yes, Judge.
All right, this is cause number CR 21262. State versus Lauren Jean Foley, and Ms. Foley is set for arraignment today. Mr. Ashmore, have you had an opportunity to review the indictment with your client?
I have. Judge, let me pull that document back up. The indictment correctly identifies her with the correct spelling of her name twice. She understands the allegations are alleged to have occurred on May 17th, 2021, and she understands the nature of the allegations and has permitted me to enter a plea of not guilty so we can negotiate with the state on this matter.
And did you also discuss with her the range of punishment?
Yes, Judge, let me pull that back. Let me go to that screen. It's not as easy to do on
I'm showing
tiny
state.
phone. State jail felony, Your Honor. with a range of punishment of 180 days up to 2 years and a $10,000 fine. You understand all that, Ms. Polk? Okay, she understands. Again, Your Honor.
All right, then the court's going to find that she's waived the formal requirements of arraignment and will enter her plea of not guilty into the record. And we'll set this matter for pretrial so that you'll have time to get the discovery on Ms. Foley's case. And Mr. Ashmore, are you available? I believe I was setting you earlier on. Let's see when I set you.
September 28th, Judge.
I want to give you, that's only 2 weeks. I want to give you more time than that so that you can get the discovery and go over it with your client, unless you think you can do all that in 2 weeks. Otherwise, I'd be setting you for either October 12th or 14th.
14th, Judge, would be requested.
Okay, court sets Ms. Foley then for pretrial on October 14th at 9 a.m. Ms. Foley, if you make bail in this case, then your hearings will be at 9 a.m. on October 14th in the Van Zandt County Courthouse. If you remain in custody, then your hearings will be at 1:30. Do you understand?
Yes, Your Honor.
Okay.
Judge, any, now let me address that off the record with my client. Never mind.
Okay. All right. So October 14th, pretrial.
All right, thank you, Judge. Yeah, I'll do it. Yeah, I don't have a seat for 1 second.
In Your Honor,
Somebody forgot their briefcase.
Mr. Adams is still
Oh,
here. Mr. Adams is here. He's got 2 clients on the docket. He's actually speaking with one right now, so Mr. Adams is not available. I know Mr. Wood is Zooming, but it's my understanding from jail staff that his client needs to be brought up separately. I do have Robert Harris in the room though.
Robert Harris. And okay, yes. So go ahead. I do have Mr. Wood available in Zoom. And so just let me know, are we going to bring him up last? Bring up his client last? Is that what we're saying?
I believe so, unless Mr. Ashmore gets done with his client, and if Mr. Adams isn't available yet, then we could bring Mr. Wood's client up at that point.
Well, let's do this. Let's bring Mr. Wood in and maybe we have a hearing without his client. I believe it's probably just a status on hospitalization. So we may not need to bring him up if jail staff has indicated that he's not doing well.
Yes, sir.
All right, let me see if I can bring Mr. Wood in. Good afternoon, Mr. Wood.
Hey, Judge.
All right, before we call Mr. Turnage's case, Deputy McLeish has indicated that the jail staff would like to bring up Mr. Turnage by himself. So that before I asked for that to be done, I was going to visit with you. And we'll go ahead and go on the record, CR 2198 and CR 2199, State versus Brett Lawrence Turnage. We're just here for a status on Vernon State Hospital. Do you request that your client appear in court today, or would you waive his appearance?
Good. I don't believe that his appearance is necessary. So on that, I think we would waive his appearance this afternoon.
Okay.
And as far as,
Well, I was just going to say then, so Deputy McLeish will not bring up Mr. Turnage.
okay. As far as Vernon goes, Judge, I called them, or Diana called them yesterday on my request to see where he was at on the list. He's number 238. So he's gone. I think he was in the 260s the last time, if I'm not mistaken. We had this hearing, I guess it was about maybe a month ago or so, but so he's moved up, not significantly, but some.
Okay.
Judge, and I independently, I requested information on where he was on the list. I didn't realize that Mr. Wood had already requested that. I haven't heard back yet. I didn't know that he was 238. I also requested some estimate as to when they expected his wait time would be. I haven't heard back, but as soon as I learn that information, I will relay that both to the court and to Mr. Wood. I copied Mr. Wood on my request, which he was, and he responded to me that 238 was his number. But I want to know so we can tell the court about how long they expect that to be.
Okay. Thank you. All right, then let's reset Mr. Turnage for another status. How about, are you available on November 30th, Mr. Wood? It's going to be the week after Thanksgiving.
Yeah, Judge, we'll be back by then. So I
Okay.
should be.
All right, so let's go ahead and set him for November 30th for a status and hope that he gets in sooner than later.
I agree.
And Judge, I will relay to the court if I get a time estimate what that is, as long as hopefully they'll respond in the same message to Mr. Wood. But I will also relay that to the court.
Yeah, you might ask Mr. Wood's staff to call for you and maybe they can get that information for you. Apparently she knows how to get that info.
Yes, Judge.
She's pretty talented, Judge.
Diane is a little bit more forceful about such things than I think I probably am. So.
All right, thank you, Mr. Wood. Is that all you have today?
That's it, Judge. Good to see you.
Good to see you. Nice haircut.
See you guys.
Nice to have hair to cut.
You know, I can't, it ain't flowing like it. Hey, thanks my wife. You can thank my wife for that.
Absolutely, will do.
All right. See you, buddy.
All right, and you said that we have Mr. Harris. Is that who you said we have, Aaron?
Yes, Your Honor.
Good morning, good morning. It's not morning anymore. Good afternoon. You are set on a motion to revoke hearing. And I see that you have requested a court-appointed attorney. My coordinator has gone through the information that you've provided. And unfortunately, you do not meet the financial requirements to receive a court-appointed attorney. So due to that, what I can do is reset your case and give you time to hire an attorney to represent you on this motion to revoke.
My family's having a hard time helping me get an attorney. Pretty much, I can't find an attorney unless I was out on my outside. It'd make it easier, but in here, I wouldn't be able to get one, even if you set me on. My family's tried so hard to find an attorney, and I'm pretty much on my own.
I understand. I don't know what to tell you other than to tell you you don't meet the legal requirements for me to give you an attorney. So
Is there any I can get out? Because I just had my aunt pass away, and she was like a mother to me. And
I understand.
I wouldn't mind going to the funeral.
I understand. At this time, Mr. Harris, I can't grant that. So I think you just need to focus on getting your family or your friends to help get a hold of your assets and do whatever they need to do to get an attorney hired so that he or she can present you on this motion to revoke. And then, you can talk with, through your attorney, you can talk with the state and figure out what's the quickest way for you to resolve your case.
I'll take more probation if it's possible.
And listen, Mr. Harris, I'm not here to negotiate with you. I'm not your lawyer and I'm not the state's lawyer, and you're not representing yourself because it looks like you are facing up to 2 to 10 years in prison. So this isn't a, Class B misdemeanor where we walk in and ask for time served. This is much more serious than that. I think you know that because you've been on probation and you've already been before this court, and you don't understand, you should understand. So I'm not, listen, we're not going to discuss what you were doing. We're not going to discuss the alleged violations. I don't want to hear any of that because it's not the appropriate time for me to hear those things. And you need an attorney to protect your rights rather than you just talking in front of two prosecutors here who could take down all your information and use it against you in your proceeding if they sought to do so. Okay. So what I'm going to do is I'm going to reset this for 2 weeks. All right. And we'll talk about it again in 2 weeks. I want you to work hard in 2 weeks and try to get an attorney to represent you. You, according to your information, you have the money and you have the assets. You just need to get somebody to do something with it.
That's what I'm trying to say. I've tried and tried to get my family help, and without my help, me out there to do whatever I can.
Well, what is it that you have to be out to do that they can't do?
My title, I mean, it's locked in my own safe.
They can't bring a title to you at the jail and have you sign it?
They're in Dallas and no one's got a car. My car is with my brother put away until I get out. And I'm on my own. That's fine.
I understand, but I mean, you want to have someone negotiate a title to your vehicle? Why can't they drive your vehicle?
That's my family's just trying to protect me on that situation because I've had so many problems, but I can't explain it. It's just I begged everybody to help me. I've tried everything.
I'm gonna give you 2 more weeks, and then 2 more weeks, you're gonna tell me, if you don't have it done, you're gonna tell me who you've talked to and all the effort that you've gone through. You understand?
Yes, sir.
All right. So I'm not setting you for 30 days. We're gonna do 2 weeks, and I expect you to work hard in the 2 weeks, reaching out to your family and tell your family that you're not gonna get a court-appointed lawyer. You're not entitled to one, that taxpayers aren't gonna pay for you to get one. And I'm sorry that you can't do the things that you want to do, but you've placed yourself where you're at today, no one else.
My family had the one issue is my family couldn't get a hold of anybody, get any attorneys or return any calls or anything. And I only can come up with $500 in cash for an attorney right now. And that's about it. And every time everybody called to try to get an attorney, no one's returned their calls or no one's taken the case, or I can't exactly speak for the rest of everybody else. But
Well, on September 28th, you tell me how many attorneys you've called and who, and their names and their phone numbers. I guarantee you, if you keep calling them, someone's going to call you back and someone's going to answer. If you don't get a hold of one attorney, then call the next one and then the next one, the next one.
And one of my family members told me that they tried calling and it just went straight to voicemail, or they never returned, or.
Well, maybe that's not the attorney for you then. That's
It's a list of attorneys I could call myself or anything. I've tried to request one, something so I could call it because if they couldn't get a hold of them. But
I'm not sure what the policies are there in the sheriff's office for you to be able to have access to computers or phone. I don't know. So I'll have my coordinator look to see if she can give you a list of attorneys to call, but I don't know, that's going to be up to you on who you hire. But if one of them's not answering, I don't think I'd call that person. All right. So September 28th, we're going to talk about it again. All right, so Mr. Adams is still working on Nelson Baker and Tristan Kimmerling.
No, Your Honor, he's actually here and ready on both.
Okay. Is Mr. Knoll working with so Mr. Houston was a waiver, I believe. So we're not bringing Mr. Theodore Houston up. I'll have to find out what that date was for the pretrial. And Miss Ashley Parker is set for contested hearing on. Well, and you know what? I think I made a mistake on that, Miss Heisel. When we discussed that this morning, I was kind of caught off guard, but it shouldn't be the 28th. It should be the 30th for the contested. Was Miss Parker the one that Mr. Knoll was saying that was going to take a contested hearing?
That's correct, Your Honor.
All right, so let's change our dockets and I'll have Ms. Taberham send notice to Mr. Knoll and to Ms. Parker that should be 9:30, not 9:28. All right, Mr. Adams, I'm sorry. You ready, sir?
I'm ready when you are, Judge.
Who do you want to go on first?
Well, let's take up Mr. Kimmerly first, I guess.
All right, CR 2293, State versus Tristan Michael Kimmerling.
Your Honor, this is going to be a plea hearing. We have an agreement, a plea agreement with the District Attorney's Office. When you are ready for those details, let me know and I will describe them to you.
Yes, sir, I'm ready.
Okay, he is charged by indictment with credit card or debit card abuse. It is a state jail felony. Our plea agreement with the DA's office is in exchange for Mr. Kimmerling's plea of guilty, that he will be sentenced to serve 2 years in the TDC State Jail Facility Division, that sentence will be suspended for 3 years, and then a fine of $4,000 plus court costs and reimbursement fees will be imposed.
How much are the court costs and reimbursement fees?
Court costs are $290. The reimbursement fees come to $585. That is a grand total of $4,875.
All right. Mr. Kimmerling, raise your right hand, sir. I'm going to place you under oath. Mr. Kimmerling, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Mr. Kimmerling, how old are you?
18.
18 years old. And if the court approves this plea agreement today, you're going to be a convicted felon today. You understand that?
Yes, sir.
Are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
And you're represented by your attorney, Mr. Mitch Adams. Are you pleased with his representation? And do you feel like you've had enough time to discuss the case with him and get all your questions answered?
Yes, sir.
Mr. Adams, do you believe Mr. Kimmerling to be competent today?
He's legally competent, Your Honor.
All right, Mr. Kimmerling, you're charged, as Mr. Adams had stated, with credit card or debit card abuse, a state jail felony that carries a range of punishment of not less than 6 months or more than 2 years confinement in the state jail division of TDC, and a fine not to exceed $10,000. That means any sentence handed down in a plea agreement or by a court or by a jury must fit within that range of punishment. You heard the plea agreement that Mr. Adams stated to the court. Is that your understanding of the plea agreement?
Yes, sir.
And that's what you're wanting the court to approve today?
Yes, sir.
All right, Mr. Kimmerling, how do you plead to credit card or debit card abuse?
Guilty.
Now, you're pleading guilty because you are guilty of committing that offense?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty to this charge?
No, sir.
Court will accept the defendant's plea of guilt at this time. Mr. Adams, any objection to states one, stipulation of evidence?
No objection, Your Honor.
Evidence is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state? And state, can you give me a summary of the facts?
Judge, on the date in question, the Grand Saline Police Department is called out to an address in where it is reported to them that the defendant took his niece's, who I believe is basically the same age, her credit card and made a number of online purchases. They locate the defendant. He admits to taking a computer and the credit card, making the purchases. The family of the victim, which is also the defendant's family, is on the phone with the representative of that business, and the charges were placed with the email address of the defendant's school email address, and he is arrested at that time. They also find the credit card thrown out a window, which is where the defendant said that he threw it.
Thank you, Mr. Wood. And Mr. Adams, you've gone over the collateral consequences of a felony conviction with your client. And the only
Yes,
reason,
sir.
one of the reasons I asked that is because of his age. And so y'all have gone over that.
That's correct, Your Honor.
Okay. All right. Is there anything further from the defense?
No, Your Honor, we rest.
All right, then based on the evidence, the court will follow the plea agreement in this case. The court convicts Tristan Michael Kimmerling of credit card or debit card abuse, assesses his punishment at 2 years confinement in the state jail division of TDC. Court will suspend that sentence and place him on community supervision for 3 years. Court orders him to pay a $4,000 fine, $290 court costs, and $585 in reimbursement fees. Mr. Kimmerling, do you understand that once you enter into your conditions of community supervision or probation, that if you violate any of those conditions by anything, if you drink alcohol, if you don't report, you don't do your community service, you don't pay your fines, court costs, reimbursement fees, do you understand if you violate any of those conditions that you've read over and signed today, that these prosecutors can file a motion to bring you back to court and they can ask this court to revoke your probation and put you into prison for up to 2 years? You understand that?
Sir.
Okay, you're 18 years old, so you have a chance to decide whether you go to prison or not. The ball's going to be in your court. You understand?
Yes, sir.
Okay. All right, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you go with the bailiff to be fingerprinted, and then the probation department will give you more information.
Yes, sir.
You ready, Mr. Adams, on Mr. Baker?
Yes, sir, I'm ready.
All right, Mr. Baker is set for motions to revoke any announcement, Mr. Adams.
Your Honor, I do not yet have a copy of the state's motions to, I think these are motions to adjudicate. If I do, well, let me take that back. Ms. Heisel made those available to me late yesterday afternoon. I have not had the opportunity to look at them yet. I was appointed to represent Mr. Baker, I think, a couple of weeks ago. So I am not ready to proceed today. We have not finalized our plea agreements or plea negotiations with the state. Because I'm not ready to proceed today because we don't have a plea agreement, in anticipation of that announcement, Your Honor, in each cause number, there are two. I have filed a motion to reduce bond. Mr. Baker has been in custody for how many days? 3 or 4 months, he says. Because I was appointed to represent him and he has been found to be indigent, I would ask the court to consider a PR bond for Mr. Baker in both cases. The bond amount in the third-degree felony case, I believe, is $50,000. The bond amount in the other matter is $100,000. There's no way on God's green earth he can pull that together. And if the court won't consider a PR bond for Mr. Baker, then I would ask the court to set bond, a surety bond for him at $5,000 in each case.
State, do you have any position on Mr. Adams' request?
Yes, and Judge, I apologize. I told you earlier this morning when I presented Mr. Adams's writ that it was not set today. I didn't realize that it was. Mr. Adams, the state is willing to agree to reduce the third-degree felony from $100,000 to a $25,000 bond, and the state jail from $50,000 down to, I believe I said $10,000. Beyond that, state would argue we didn't have notice for a hearing and ask that a hearing be reset if necessary.
Mr. Adams, do you want to talk to your client about that, or do you have a response to the notice argument?
No, Judge, the motions were filed yesterday.
Okay,
So, that's ABC right there.
okay. All right, so the court will set Mr. Baker then for the contested docket on October 28th. If there's no plea agreement reached, the court will take his matter up in a contested hearing. And we will, if you want a hearing on the motion to reduce bond, we could set that on September 20. We could set that on September 30th. Or the court can sign the, if there's an agreement on the.
Judge, I have another, on that date, September 30th, that afternoon, I have another matter set on the revocation docket, so we might as well add this one to that docket for a contested hearing on the bond issue.
Okay, so you do not want the court to reduce bond to 25,000 on the possession charge and 10,000 on the theft for a total of 35?
Put that together, $3,500, $3,500. Yes, sir. It's not. Judge, if you could go ahead and sign those orders to reduce the bonds to those amounts. Mr. Baker says that he thinks that he might be able to go that.
Okay, all right, the court will sign the order reducing bail to $10,000 in CR 16293 and $25,000 in CR 1747. And we'll have Mr. Baker's case heard on October 28th if there's no agreement before then or at that time.
Yes, sir. Judge, I believe that's all I have on the course docket for the afternoon, unless there's something that you have a pleasant surprise for me of some kind. I'd ask to be excused otherwise.
You know, I don't believe I do, so I would walk quickly out. You never know where Ms. Tabraham may be. She could be around the corner.
I can only go so far, so fast as the deputies will let me today, Judge.
I do believe Miss Abraham gave him a surprise this morning, so.
Okay.
That's true. Yes, I think you did get a first-degree felony possession or manufacturing case. Can't remember which one it was. And so I told her to give you a day or two to get information. And so we gave her your contact information. She's on bail, so she'll be in contact.
All right, very good. Appreciate
it. You really are a captive audience today, are you not?
I guess I am. Yeah, that's right.
Have a good day. Be safe.
Thank you, Judge.
All right, I believe that completes our jail docket.
Yes, it does.
Houston, yes, I tell you what, let me check with Ms. Tabraham on the waiver of arraignment date, setting pretrial on Theodore Houston, so I can get that to the state. Hang on just one moment. And Aaron, you can go ahead and log off if you want to. State, if you'll stick around, I'll get you that date. All right, Mr. Theodore Elias Houston is set for pretrial by waiver on October 10th. I'm sorry, October 12th. October 12th.
And Judge, if you will, in the YouTube recording and the recording of this, just wanted to provide you